let's jump right in. Basically, today we are going to tackle three areas. First, introduction to fundraising laws and regulations, just an overview of the regulatory system in Kenya that is specifically designed to control fundraising. And then afterwards, we'll look at corporate sponsorships and partnerships, like the kind of vehicles that you can get into just to um, maximize your potential, either through a vehicle where you are in partnership or you are conjoined with someone else, and also the legal strategies for grant applications, because I'm sure, I mean, this goes hand in hand with fundraising, because uh, at some point you'll have to apply for a grant if you want to, maybe, let's say, expand your business or something of that sort. So I'll start with fundraising laws and regulations. So in Kenya, uh, fundraising, or rather crowdfunding as it's known around, is something that has been, rather, the regulating of such activities has started not so long ago. I think around 2012, 2013 to 2015 is when laws and regulations were properly laid out, because it was something that was not very common. But then I think with time it has become something big, something more frequent, and of course it has to be governed just to make sure that everything goes smoothly. So at the moment, fundraising, or rather crowdfunding, is regulated by the Capital Markets Authority. This is a body that has been given authority under CBK, under the Central Bank of Kenya. So that now they specifically try and regulate and make sure that crowdfunding and such issues are properly regulated, properly viewed, licensed, and everything. And of course, also this Capital Market Authority is given, the mandate by the Capital Markets Act. So that is the governing law. When you talk like the specific governing law, so anything to do with crowdfunding, all the laws and regulations can be found in the Capital Markets Act. So here, when you're talking about fundraising or crowdfunding, of course, they have to look at the different types of companies that are there. So for a public company, uh, public meaning, it's not limited. Um it is created, let's say, when a few, or rather not a few, when people come together, but then all they create a vehicle to trade, do business, but there are no limitations to liability. So for public companies, of course, they have a different regulation, but of course, rather, they really looked into it and saw that a lot of private companies also will get into this space, and they tried to create laws and regulations to also control companies. And for, let's say, private limited companies, so either limited by shares or limited by guarantee, you can make offers to private investors. Be When I'm talking about private investors, either an individual or a group of people, let's say an institution, something like a bank, or venture capital companies that have started coming up also. So yeah, you can make private offers just to get some funding from them. And well, this like the private individuals that you'll be approaching to fundraise or do crowdfunding with, they have different ways of taking up or other fundraising, because when you want to raise some funds, of course you have to give something in return. And in most cases, companies give some part of their shares, or
Mr. Kemba,
yes.
Sorry to cut you short. I see someone saying the PowerPoint, the slides are not moving. Are you scrolling up and down? Not yet.
I'm still at introduction to fundraising laws. I hope everyone is there, but I'll be moving shortly.
Good. See, shows people are attentive. Thank you.
Okay. Yeah. So as I was saying, that different investors have different ways of getting something in return for them to give you your funds, or rather for them to give you their funds. So yeah, there are different ways which we'll discuss later on. And of course, the process has to be regulated to make sure that investors do not lose money to fraudulent fundraisers. I think we've all seen, was it Flutterwave? Or, yeah, I think it was Flutterwave, where, I mean, people put in a lot of money and it just disappeared. So, yeah, the government is trying to regulate such things just to make sure that investors do not lose their money to fraudulent fundraisers, or do not even contribute to things like money laundering, funding terrorism. I think, I mean, it's a whole discussion, but the main point is just to make sure that number one, investors are protected, and then also the money that is being sourced will be put into good use. So I'm on the next slide. I hope everyone is there. Linda, you can just confirm quickly.
Can we all see the next
qualifications for a company to be allowed to crowdfund? I hope everyone is seeing that.
No. Could you try scroll? Is it your slide number 2? Because we are still on slide. We can only from my side I can only see slide number 1.
Let me just check on my end.
Okay. Now it shows number 4.
Yes, that's where I am.
Awesome. Okay.
Yeah, so basically for a company to qualify, or rather now here we are talking about a private company. For a company to be allowed to do funding, the law gives some qualifications that company has to meet. So the first requirement is for that company to be incorporated in Kenya, of course, and it should have a minimum of 2 years operating track record. So when they ask you to bring your documents, of course, one of the documents that they'll ask for you to bring is the CR12, which is the company search, and the company search usually has the date of incorporation. So if they see that you've not been operating for a minimum of 2 years, of course, you will not be allowed to, crowdfund or fundraise. So they just want to see some track record of operation of the company, so that it's not just a facade where people want to, get money without showing what they've been doing. The second qualification is good corporate governance record. So when you're talking about corporate governance, there are some statutory obligations that you have to do as a company. First, of course, when it comes to tax, you must be tax compliant, and I think you can, if you have been paying taxes as a company, you can easily get the tax compliance certificate from KRA. Secondly, a company incorporated, let's say if it is a private limited company, limited by shares, of course you have to hold AGMs or any kind of meetings, and any decision that the company decides to take. I mean, there have to be some minutes, some a meeting of minds with the directors and the shareholders, such things. So I mean, you have to have a record of AGMs, meetings. Apart from that, there is annual returns that companies are supposed to file just to show, if there are any shares transferred, the current list of directors, current list of shareholders, if there's any change of location or address with the company, like all these things, you have to have a record of them. So that's what I talk about when when we are referring to corporate governance. It's a whole it's a whole discussion. I think maybe sometime later we can delve into it, or Linda here with Mainland Capital can try and arrange a separate session for that. But I think it's also, I feel like it's a very important thing because a lot of people do not know. They just incorporate companies not knowing the corporate governance part of them. So, of course, when you're applying to get the fundraising licensing and approval from the CMA, you have to state which investment instrument you will offer to the investors. So investment instruments, I think I've talked about it in the previous slide. You can decide to offer shares. You can decide to offer equity. You can decide to offer things like convertible notes, safes, just something that you're giving in return of the funds that investors will give you. So I mean, there are several instruments. It's up to you to, once you get to that stage, it's up to you to look at what is suitable for you, like what you're trying to achieve. Because I mean, venture capital companies mostly go for shares. They want a stake of shares in your company, and they'll either reciprocate by giving you an amount similar to the shares that they've acquired, and come to an agreement that once the company has made some milestones, they'll withdraw and transfer the shares back to you. So yeah, there are different ways of going about it. So my advice when it comes to this is once you get to this stage, do some research on the various investment instruments. Feel free to reach out to me, ask any kind of questions that you might have from the research that you've come about, and also understand the implication of the instrument, because you might, let's say for future equity, you might cause that I'll use an example of future equity where you're given a loan, and then now when it comes to us, or rather when it reaches to a certain time, this loan is converted into equity, which means that you have to give some shares to the investor. So it's important to understand the implications of such instruments before getting into them, so that you don't find yourself in a situation where you've given a certain instrument and then it brings some complications with the investor later on. So also the law gives companies that are restricted from fundraising, as I mentioned, public listed companies and their subsidiaries, they cannot approach private investors to do that. I talked about corporate governance. Of course, entities with a poor governance record, no filing of returns, no filing of annual returns as well, no AGM meeting, no AGM records, no meetings, nothing. So this will give you some trouble. So I think, Linda, you can talk to Melanie and Ian. We see if we can arrange a session for corporate governance, because I think it's a bit important.
Yeah, sure.
And it's something that we've seen companies getting disqualified from so many things because of that. Because people just incorporate companies, trade with them, but then they forget the the corporate governance side of it. So also entities that intend to use the funds raised to provide loans, of course, this will be a problem because you cannot get money from investors and then put it into a loan business. Now you see, companies, or rather, I mean the usual companies that we know, Tala, Branch, whatnot. For them, they cannot approach investors to invest in their companies because it's by law in Kenya. This is restricted because you have to provide a detailed report of how you're going to use the money that you intend to fundraise. So when it comes to entities that want to that want to get into the business of providing loans to other people, then they are regulated separately by CBK. So they will not fall in this category, and for them, fundraising for their part is I'm not quite sure, but that is mostly regulated by CBK. And also the funds that you're getting, you cannot start investing in other entities. This is specifically to invest in your own company and to make sure that your company grows. If it is expansion, if it is whatever intent that you had, but it should not be to invest in other companies. And also there's I mean, once you submit your request for an approval to the Capital Markets Authority, they have the discretion to determine which entity cannot raise funds through approaching investors and whatnot. And of course, once they decline your request, they'll always give an explanation as to why that has been rejected. So when you're talking about investors, they have to be eligible investors, and the law specifies that they have to be a category called sophisticated investor. So a sophisticated investor is basically someone who understands and has knowledge about investments, business matters, and anything to do with fundraising. So you cannot just approach just anyone. If you submit a list of investors to CMA, they'll want to confirm that these are people who understand what they are getting themselves into. They understand matters investment, they understand matters running a company, they understand matters to do with the investment instruments. So and I've seen the CMA going to the length of calling in people who are listed as investors and trying to ascertain if they fit in this category of sophisticated investors. So this is a very crucial point that you have to look at when you want to do fundraising. So you just do not approach just anyone. Just because someone, let's say, has a high amount of money doesn't make them a sophisticated investor. This person has to understand what investment is, what business is, what the investment instrument you're offering is. So this is a very important point, because once you make that application, of course, they'll ask you to list the investors that you have. And this is also a point that disqualifies a lot of companies from being given the approval to fundraise. So also there are those called retail investors. Now the problem with the retail investors, the law has not, given a proper definition of who retail investors are. But they've just said that they are subject to some investment limits. But from my understanding, I think now when you're talking about retail investors, you're talking about people like angel investors, venture capital investors or other companies that, of course, they want to invest in companies. I think this is the definition of them. I'm not quite sure with there's a loophole left there that is subject to so much interpretation. But I think the CMA is trying to work on trying to properly expound on who retail investors are the way they've done with sophisticated investors. But of course, there are some investment limits that retail investors must meet that is prescribed by the CMA. As I've said, at the moment, there are no limits that have been put, but it is left to the discretion of the CMA to come up with these limits and determine who is a retail investor. I have moved. Linda, please confirm that you can see a different slide from the previous one.
No, I can still see slide number 4.
Oh, okay. I had moved some slides. Okay, just a minute. What about now?
Still, it's not moved. Not unless someone else in the room can confirm they can see a different slide. I am seeing slide number 6.
Number 6, okay.
Yes.
Okay, yeah, that's where we are. I hope everyone is on the same.
Yeah, I hope as you move to the next slide, just you can check with us, because we were still stuck at slide number 4, I think. Okay.
Okay, no problem. But I think actually at the end of this, I'll just share the presentation so that everyone gets to have a look at it.
Awesome.
Yeah. So yeah, right now I'd want to discuss like the basic funding rules and regulations that are there. So once you approach sophisticated investors, as I've explained before, you are, or rather the law prescribes that you can fundraise a maximum of 100 million in 1 year. So that is the maximum set. There's no minimum set, but the maximum set figure that you can fundraise in 1 year. Now the problem is they have not specified if it is 1 calendar year or 1 financial year, because I believe, or rather I know that financial years are different, ranging from company to company. But in the law, if there's no prescribed, you usually go with a calendar year. So the law prescribes that you cannot exceed 100 million in 1 year in terms of fundraising. And if you wish to raise more than that 1 million, or rather 100 million, you have to contact the CMA and get approval from them to surpass that limit. But the limit set for the maximum amount that you can raise in 1 year is 100 million. And of course, you have to notify the CMA that you intend to, have some investors come, and this is usually done by filling 2 forms. There's one called a short form prospectus and an information notice. These documents can be gotten from the CMA website. So once you get to that point where you'd want to fundraise, you just visit the CMA website, and these 2 documents are usually there. So in this short form prospectus and the information notice, you will fill in, your company details and what you intend to do with the money. I think, let me just see if I have. I think I do have these documents. You can just actually open them. Of course, you must have an offering document that outlines the investor's rights and ownership of the investment instruments to be shared. So in this case, if you if you're going the route of issuing shares, of course, be it a share transfer agreement or when it comes to the future equity, there's usually a document called a SAFE. It's called Simple Agreement for Future Equity. Just an agreement that stipulates the rights and ownership um, and obligations of the investor and also the company that is offering the investment instrument. So this has to be stated clearly, and also it is also important to have a format or a template of the same that you wish to use. And of course, in such an instance, you can always also approach me or any other legal person just to have one drafted, because it's usually good when it's drafted from a legal perspective, because at the end of the day, the investor right, but also we have to protect a few things that will make sure that the investor does not completely interfere with the running of the company, and that you also have some control over what you do with the funds. So as I've said, I think I've mentioned this earlier, you have to state the use of the funds. So this is where now the CMA will ascertain if you qualified for funding or not. So you have to properly state the use of the funds. And in the event that you wish to take the funds outside the country, you have to state this as well. And also make sure that whichever country that you wish to take the funds to also has a mechanism of protecting investors in the event of money getting lost or fraudulent activities, such things. I mean, you just have to state where exactly it will be going, and you have to make sure that whichever country that the funds will be used, there are some regulations and rules that will protect the investor. And of course, our very new law that has been a bit misunderstood but very important is to comply with all applicable laws relating to data protection and privacy. So here, the issue of data protection and privacy comes in because you have names of people, personal identifiers, if I may call it that, because you have names, ID numbers, phone numbers. It might get to a point where there are some pictures, so such things you have to comply with all data protection and privacy regulations that are put up in the Data Protection Act 2019. Also, I think Linda, you'll also see we can also have a session about data protection, because a lot of companies are suffering from this as they do not have the know-how of how to handle this new law. I've moved to a new slide. It's still the same on rules and regulations. So in the event that the CMA realizes that you've given an
slide number 7.
Yes.
We are still on
number 6.
Yes.
Okay, just a minute. I rectify that. I hope now you can see 7.
Yes.
Yes. So as I was saying, in the event that CMA realizes that you've given incorrect information on the forms that I talked about, the short form in prospectus and information notice, you'll be liable of a criminal. Okay, no, they've not stated if it's criminal or not, but they've put a penalty for giving incorrect information, and this can lead to a fine of around 10 million for an individual. And if you're a company, the fine that will be given as a company is 30 million. So this is just to make sure that people do not give incorrect information on the short form prospectus. So they've given some penalties that, of course, will try and scare you off, just to make sure that you give some proper information on the short form prospectus and information notice. And the thing with the short form prospectus and information notice, there are some documents that will be asked to attach with these forms when you're submitting. So it's just prudent just to make sure that you give the correct information. And a company has to keep a record of fundraised funds, because this is necessary to prepare financial statements in conformity with international financial reporting standards. So of course, if you've done crowdfunding before, you have to keep a record of that, or of the funds that you received, of how these funds were used, and in the event that there was a balance, how this balance has been utilized, or if there's any kind of agreement between you and the investor, maybe to give that money back or to invest it somewhere else. But you must have a proper financial statement of the crowdfunded, of the funds raised, and this has to be in conformity with the international financial reporting standards, so that it is understood anywhere by any financial analyst or financial person that will come across these statements. So yes, I am done with the issue of crowdfunding. Now I'd like to take some questions just before we move to the other session. So if there's anyone with a question.
If you have a question, you can raise your hand, and I can enable your mic, or you can write it on the chat, or Q&A, and I'll read it. Anyone with a question? We are
Okay.
very quiet here. I think it's getting serious.
It's okay, but anyway, I'll take the silence as an indication that people have understood.
Yeah, exactly.
Yes. So we'll jump into the second. Part, which is basically corporate sponsorships and partnerships. So I think this was a question that I was getting a lot when we were having the private consultations. So you can do collaborations, because sometimes it's a bit hard for a company. Let's say you're just starting and getting access to capital or some funds to get into the right market or expand into the market. Sometimes it can be a bit hard, and I've seen people complement this by joining hands with companies in the same industry, or just doing something that will make them accessible to markets, to capital or expansion. So there are some legal collaborations that you can get into, and today we'll be talking about joint ventures, partnerships, consortiums, mergers, and strategic alliances. So of course, this is, collaborations are usually good for competition, because if you, let's say 100 firms in one industry, of course, the cooperation that will come on top is the one that has access to capital and the market. So the bottom, or rather the small companies will have to face a lot of stiff competition from the companies that have access to everything. So if you decide to collaborate, let's say 10 small companies, you can pull some resources together, and this will make you have some access to capital and the market. And also I mean, small companies can also collaborate with established companies, because you see, with established companies, they already have resources, they already have a share of the market, and they understand the ins and outs of the industry. So, I mean, as a startup, as a small company that is not accessible to all these things, you can actually benefit from collaborating with established companies, because you get to know how to maneuver the industry, you get to access some sort of capital from them, and you also get to enter into the market that the established companies have already entered into. I have moved to the next slide on partnerships. I hope, Linda, everyone is seeing this. Linda, just quickly confirm so that we proceed.
Yeah, sorry, I didn't realize I was muted. Yeah, we're still on slide number 8.
Yeah, okay. I'm on partnerships at the moment. Let me just try and I think
Yes.
number 9 now.
Yes, you can see the partnership slide.
Okay, yeah, so good. Yeah, so one of the collaborations one can do is a partnership. So you can decide to come together with someone and create a vehicle that's known as a partnership, and this is mostly for people with a common goal of making a profit. So, and when you're choosing a partnership, you can there are two types of partnerships. There's the general partnership and a limited liability partnership. So the difference is this: with a general partnership, basically you're just coming together with someone to pool resources. But then now the vehicle that will be created with the general partnership, profits and losses are usually shared between the partners. And then in the event of liability, also this is shared between the partners. So if there's let's say a legal liability, let's say like a case, the partners, both of them are liable, even if it's one partner who has done it. So for general partnership, the partners are considered as the partnership. But then when you come to a limited liability partnership, it's like you've created a company which has uh, it's like an entity on its own, which can be sued and sue. So in a general partnership, in the event that there's a legal liability, the partners will be liable to it, or rather you can sue the two partners. But in a limited liability partnership, it will be you are suing the partnership, not the partners. I hope this point is coming out clear. So these are the two different partnerships that are there. And of course, profits and losses are shared between the partners, depending on the contribution ratio in general partnerships. So if there's a profit, then depending on the contribution ratio, if let's say I'm in business with Linda and I've given 30% and she's come up with 70%, then when it comes to profits, that's the same ratio that we use to distribute the profits. And then also, I mean, as I've said, in general partnerships, all liability rests on the partners, while in the limited liability partnership, which is also known as the LLP, the liability rests on the entity without spreading to the partners. So normally partnerships are good for long-term collaborations. If you foresee, like, let's say if you want to do something for 10, 15, 20 years, this is a good way of going with it, because this is something that is actually registered. I am moving to the other slide on joint ventures. I hope everyone is on this.
Yes.
Okay, good. So Another vehicle is a joint venture. Normally, this happens where, you know, I'm a company, you're a company, and there's another company. We can decide to, form an entity where we are pulling, or rather, let's say there are like 4 entities that want to do a specific project or achieve something, let's say in the market. Let's say they want to enter into a specific market that, if they enter individually, it might be a bit tough. But if they decide to come together, they can easily do it. So a joint venture, normally 2 or more entities, you've just decided that we have maybe a specific project or a specific goal to meet. So we'll just pull our resources together and come in and achieve that. So I'll give you a very good example of a joint venture. At the moment, I mean, there's so many apartments coming up in Nairobi. So what is happening is because, let's say, the owner of the land cannot raise such an amount to come up with such a big project. So the owner of the land will create a partnership with, let's say, a developer, and a developer will create a partnership with an architect or an architectural firm. So they come together to, they have a specific project which is coming up with an apartment. So this is an example of a joint venture where people will, pull their resources together, come up with a specific project, and then once it's done, they split, but they agree on, losses, profits, and liability, and all sorts of things. So at the moment, joint ventures are being regulated by the Competition Act, and the Competition Authority of Kenya is the governing body that is looking into joint ventures. So as I've said, each party will be liable for profits and losses. But then in terms of liability, the joint venture will be taken as an entity on its own. So it will not be it will not be like a profit or losses where each party is liable on its own. So once legal liability arises, you can sue the joint venture on its own. But then once it comes to profits and losses, this is a discussion that the parties in the joint venture will have together. And in the event of a profit, then the profit is distributed according to what they had agreed. If it is a loss, the same is done. But once it comes to a liability, let's say like being sued or suing, they can do a joint venture will be considered a separate entity from the parties forming it, and it will be taken as an entity on its own. Yeah, so as I've said, it's normally just formed to pool resources, to combine expertise, and mostly enter into foreign markets. So for businesses, if businesses want to venture, I think with now the East Africa community bringing in Congo as a member state, for Kenyan companies to enter into such a market, it is advisable to do it as a joint venture, just to make sure that liability is limited to the entity and not the specific parties. And it's also good capital wise, because here you're combining resources, combining expertise, so it is good for that. And then also this is suitable for short-term projects or specific projects that you want to do. So if it's something short-term, then this is a good vehicle to use once you in the event that you want to collaborate with another company or any other body. I have moved to the next one. Linda, just confirm consortium.
Yes, I can see it.
Okay, good. So a consortium I think there's no proper legal definition for it, but how it works, it's like a less formal joint venture. It's like a casual joint venture, if I can use that word. So it's just the same as a joint venture. People, pulling resources, just coming in together to, form something that can drive them into whatever they want to achieve. And here, there's no separate entity registered, and it is more of an agreement between parties. So when you're talking about a partnership can be legally registered. When you're talking about a joint venture can be legally registered. But then a consortium, it's not a must for it to be registered. It can just be a product of an agreement where we sit down 3 or 4 companies and then we say that this is our goal. We do not wish to really register it as such, but then we want to come to an agreement that this is what we want to do with, or rather this is what we want to do together. So it is more of a product of an agreement, written or implied, whichever is okay. But so long as that there is proof that there is that pulling of resources together. And then also when it comes to profits, losses, taxes, liabilities, every party will have its own liability. So in the event that one party in the consortium does something that will bring a loss to the entire consortium, then that specific party will be liable for that loss. If it's taxes, everyone pays their own tax. If it is liabilities, everyone will have to deal with their own liabilities without involving the other party. So, of course, this is something that, or rather, it is suitable if you want to do a short-term project without losing control of your company. Because when it comes to a joint venture, this is more of you losing some control over your company because you're joining it with another company. So if you want to do something short-term without really losing complete control over not even complete. Like if you do not want to lose any kind of control over your company, a consortium is the best thing because this is something that's not legally registered as an entity, and I mean it's just an agreement that we are going to do this, and everyone retains their own control. And once this project is done, then the consortium is dissolved. I hope that is. I hope that is okay. I have moved to mergers. Mergers, please,
Yes.
Linda.
And say it, yes.
Okay, thank you.
Yeah.
So I think mergers and acquisition is a term that everyone has come across. So basically, a merger is I have decided to either sell my company to another company, or I've decided to buy another company, be it shares and assets, and then, or in the event that two companies come together and they say that we'll stop operating as two different entities, let's join forces. Like what you're going to do is, if there are two companies, let's say company A and B, they'll come together and it will be no longer company A and B. They'll now join forces and form company C. And company A and B will stop existing once the merger has gone through. I hope this is clear.
Yeah.
So here we are talking about two companies coming together, and once the merger has gone through, these two companies will stop existing completely. It will be now one company, one different company from the two. As much as it is two companies coming together to form one, these two companies will stop existing once the merger has gone through. I hope that is clear.
Yes.
So yeah, mergers are normally regulated by the company, by the Competition Act and regulated by the Competition Authority of Kenya. So any kind of merger that you want to do, the Competition Authority of Kenya has to be notified and give authorization on the same. I think for approval from the from the Competition Act of Authority of Kenya, sorry, it also depends on the value of the mergers. So if it is above, I cannot remember that figure, but if it is really high, then the Competition Authority of Kenya has to make sure that you're not trying to create a monopoly. They still want to make sure that the competition is fair, so they have to regulate mergers. So as I've said initially, when a merger happens, the old entity cease to exist completely. So if company A had assets, they'll not be considered assets of company C. If it is if it is shares, liabilities, all those things, they'll stop existing and now fall under the ownership of the new company that is formed. So remember, this is a permanent collaboration. This one, there's no coming out of it. For partnerships, you can decide to dissolve and go back to your old company. For joint ventures, the same thing. You can decide to dissolve and go back to your company. For consortiums, of course, this is that's just something short that once you've met the specific objective, it will be dissolved. But here, this is a permanent collaboration. There's no coming out of this. I hope that is clear. Like to move to the next slide. Linda, please confirm.
Yes, totally.
Pointers. So yeah, good. So in the event that you want to consider collaboration, I'll just give you a few pointers, but it is always good to consult. Here, I think two professions will come in handy. Of course, a lawyer, just to give you the legal implications of the collaboration, and also a business person, or rather like a financial advisor, analyst, and like that sort of profession, just to also give you the commercial aspect of collaboration. But I mean, the pointers that people, or rather the common pointers that you should look at is a profit and loss sharing formula. You have to look at the formula that is suitable to you, because there are sometimes you'll make profits, there are sometimes you'll make losses. So you have to make sure that that formula really suits you in terms of both profits and losses. You also have to look at taxes. There are some vehicles where you will pay taxes individually. There are some vehicles where, in terms of tax, they'll be considered an entity, like joint ventures and a joint venture and a merger. Now that specific entity will be considered as a simple entity when it comes to taxes. But in partnerships, especially general partnerships, you as a partner will have to pay your own taxes. In a consortium, you as an individual will have to pay your own taxes. So this is something that is very important to look at. Also, limitation of liability. When you get into any kind of commercial contract, you have to look at, in the event that there's a liability that is my own, what is the extent of this liability? My advice always is that this liability should not exceed what you're bringing into the business. So if you're bringing in, let's say, 10 million, that liability should, or rather the liability should be capped at 10 million, just to make sure that you do not have to incur more liability than what you're bringing into the business. The next thing is the extent of control. As I've said, for a partnership, of course, there's you have some control over it. For a joint venture, there's some control over it. For a consortium also, you have some control over your entity or yourself. But then when it comes to mergers, of course, here we are talking something different because now this is a permanent collaboration. Whatever influence or control that you had in your own company, here you'll have to share it with someone else. So that is something that is very important to look at. The other thing, of course, pooling of resources, because this is the whole point of you collaborating. So look at what you're bringing, look at what the other party is bringing. Make sure that whatever is being pulled in this pool of resources is also going to benefit you in one way or another. And make sure that the other party does not benefit more from you and you're not benefiting anything from them. So this is a very important pointer to look at. Also, assets acquired during collaboration. Now, this is a very tricky part because now with different vehicles, it becomes a bit different, like it becomes a bit trickier because when you acquire something in a partnership, if you acquire an asset, let's say you acquire land or a vehicle, in the event of dissolution, in a partnership, of course, they'll have to look at the contributing formula. If you contributed 70%, then in the event of a dissolution of a partnership, that asset you own 70% of it. If it is now things like a consortium or a joint venture, this becomes a bit tricky because unless now this is something that you have to put in the agreement at the beginning and say that if someone contributes a certain amount of money towards the acquisition of a certain asset, then in the event of dissolution, then this person will be will own or will be entitled to a certain, rather either the contributing amount or full or, and I mean, this is the discussion that you must have during the collaboration process. Because I mean, in a joint venture, for example, if it is building an apartment, maybe the developer does not have, let's say, earth movers or something of that sort. But then once they get into the joint venture, then I mean, all the parties contribute towards the acquisition of such an asset. So you have to look at these things way before getting into a collaboration so that in the event of dissolution, there's no conflict about the assets. Of course, conflict resolution, this has to be looked at. So in the event of a conflict in the collaborative vehicle, what do you go to? Do you go to mediation? Do you go to arbitration? Do you go the litigation way? So it's up to you to look at these things, make sure that it is suitable, it is something that can work fast, and something that will not be expensive for you to go through with. And of course, the last thing, exit strategies. So if it is for a specific purpose, of course, put it down that once a specific objective has been met, then the vehicle will be dissolved. So yeah, these are some important pointers, but it's always good to consult some professionals just to make sure that all your bases are covered. Up to there, any question? Happy to take any that you have.
Yeah, I can't see any question. Anyone with a question?
But the last part is not so long. I think we can do over 5 minutes. I know I've exceeded the time.
Yeah. Anyone with a question, you can raise your hand or you can write it on the chat and I can read it out and Mr. Kaimba can answer them. I think, Mr. Kaimba, we can continue. If I see, I am very active on the chat. I'm looking out, and if anyone raises their hand, I'll be sure to give them the opportunity to ask their questions.
Okay, thank you for that. Now the last part, which is fairly easy, legal strategies for grant applications. So here now we are not dealing with the CMA or fundraising applications and whatnot. Here we are dealing with the investor. So I mean, when you're making a grant application, of course the investor has to look at how your company is trading, how is it being run, and are there measures that you've put in the event of, I mean, there are so many things coming up in the business space. So it is always good to be up to date with these things, just to make sure that whenever you're doing a grant application, the investors can see that also you're running the business in a proper way, because of course if you're not running your business in a proper way, I do not think there's anyone who will want to invest in your company. So I just put up a few pointers that I feel are usually strong points, and I've seen companies try to navigate this, and also for the few investors I've talked about, like these are the things that they always look at when when it's time to give grants, give funding or any kind of investing. So first of all, governance of the company. I think this is the fourth time or third time I'm mentioning it, but of course, governance of the company, annual returns, AGMs, meetings, board meetings with the directors, board meetings with the shareholders, all these kinds of things. But even on the governance of the company, also this extends to employee matters, how you recruit, how you let go of employees, all these things have an impact on the governance of the company. So yeah, please, Linda, I think this is something very important that these people have to learn before the end of the program, and I think it needs its own session on its own, because I think it's a So of course the other thing, tax compliance. I think this is a bit self-explanatory, but it's always good to insist. Investors do not want to get into business with someone who has tax issues. Be it you failed to remit corporate tax, be it you're failing to remit PAYE, NHIF, NSSF, all those things, housing levy now that it's now that it's low, such things. Just make sure that every time when it comes to tax, do what you have to do just to make sure that you're in the good books. And from the KRA portal, you can always get a tax compliance certificate, which is, I think, valid for normally a year, like that financial year. So once you have that tax compliance certificate, then this boosts your chances of getting, financing from investors. Another thing, financials. Your financial statements, I cannot get much into it because I'm not very good with finances, but I know, things like financial statements that show the financial position of the company, how you've been handling your finances, how you've been making money, and how you intend. Once investors look at these things, it gives them an indication of how you're going to grow or if something will go wrong. I mean, these are the financial statements are the documents that I usually looked at when they are trying to determine whether to invest or not. So these are very crucial documents that one must have, and it's a good point that they conform to the international financial reporting standards. So yeah, have that. Um, have have a financial person on retainer, or someone working just for you, just to make sure that these statements, these books are in order. And also now you see, even for tax compliance, of course, you must have these financial statements and everything in order. Even for the governance, the financials are also important. So this is a very crucial aspect. I think I should have even put it as number one, but I'll not get so much into it. I think you as business people, you understand it more than me. But yeah, very crucial point. So the other issue is anti-bribery, anti-money laundering, and countering terrorism funding policies. So this is something that I've seen, especially with foreign investors. They want to see if your company has some policies that will make sure that the business is not used to launder money. The business is not used to fund terrorism. Your business does not participate in bribery, corruption, such things. And now the problem is, Kenya has some reputation. I'm sorry to say, but it's the truth. It has some reputation of corruption, where you see some companies are being formed by cronies of politicians, just to make sure that they're the ones getting government tenders and such issues. So it is always good to have these policies. And when it comes to money laundering and funding terrorism, I think, was it January or February, Kenya was put on the grey list by the IMF because of money laundering. So the IMF feels like a lot of activities in Kenya are revolving around money laundering. So it is good to have a policy for your company, and also make sure that you're not on the radar of the anti-corruption uh, the anti-corruption agency, or any kind of thing. But it is always good to have these policies. If you show them, especially to foreign to foreigner to foreign investors, then it becomes a boosting point for you to have this. And of course, you can approach me, you can approach any legal person to come up with these policies. I feel they're very important in the when you're trying to apply for grants and any kind of investments that you'd want people to come and do in your company. When I think I mentioned about employees in the governance of the company. So also foreign investors also look at how you're treating your employees, how they're conducting business at the office. So it is always good to have a handbook that is given to employees at the beginning of their employment. So the handbook will just have, it is basically a guide for employees on how to act. And also now, because during onboarding, you have to tell the employee that this is how this is run here. This is how we do things. This is not. This is what is not. This is what you're not supposed to do. So it will help if you have an employee and also as well, you can approach me or any other legal person to have a handbook that complies with the employment laws in Kenya, or whichever country that you want to do your business. It is always good to have the handbook reflecting what the employment laws stipulate in that country, and also now your own rules that you want to apply in the office. So yeah, that's a very important thing. Of course, also this I should put it as number 2, licenses, approvals, certifications. So in whatever field that you are, what I know is if you have an office, you must have a business permit issued by a county. So be it Nairobi, be it Machakos, be it Kiambu, be it Nakuru, every county issues licenses. I mean, they're usually known as business permits. So yes, there is that. And then now, depending on the particular field that you're in, certifications. For example, I as an advocate, I must get some certifications from the Law Society of Kenya to operate. When it comes to food, I think there are some things like KEBS, like if you're manufacturing something, you must get some certifications and approval from KEBS. Or I'm trying to look at a specific industry. I think for tourism, there are some licenses, approvals, and certifications that are given by the tourism board. If it is running a hotel, such things. So make sure that you have all these things put across. If you're operating, of course, a factory, there are some, things like is it occupational safety and health act. There's an approval that is given by that. So any kind of approval or certification or license that you're supposed to acquire from any relevant body, please have it. It will give you additional points because it shows that you're operating legally. I hope that is clear, but you feel free to reach out. I mean, once you tell me the specific industry that you're operating in, I can be able to single out the different licenses or approval or certifications that you may need and the issuing offices, and help you in making those applications and getting those licenses. So another thing, or rather the last thing, is political affiliations. At the moment, a lot of foreign investors are avoiding any companies, any businesses that are run or have political affiliations, simply because I mean, there's been a trend where politicians use these companies either to gain tenders for themselves, any corrupt deals and whatnot. I mean, this is something that has been in the news and you're all aware of. So it is advisable to have little to no political affiliations in your companies, because at the end of the day, this is something that you'll be asked about, and if you lie, of course, there'll be consequences, because I mean, these things always come out. So it is advisable. I'm not saying that having a politician is bad, but the picture that has been put before, it might affect your applications for grants.